Oh my goodness. Can y'all hear me now? I've been talking and talking and talking and talking. I haven't done this in a while, you can tell. I went by and like told everybody hi. So let me do it again. Hi Dawn, hi Caroline. Hey Ember, hey Jen and James. I don't know what this is though, guys. I have no clue. I think it might be a mistake. I don't have any idea what's happening, and I got to try to repeat everything I just said a second ago. I don't know what's happening. I don't know. It might be a mistake, but we popped up on here just to find out like what might be happening. I got a comment on another post saying, "Hey, I just got a notification that they're about to go live in like 30 minutes." And I'm like, "What?" So I just went ahead and popped this up just in case. Hello, 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 everybody. I know I have stuff I have to do right as soon as I'm like done with what I'm already doing. So I'm like, well, what in the world is this? I feel like 4 o'clock is a little late, but I guess we shall see what's happening because I just do not know. I'm going to start doing more lives, Tay. I need to get my members only schedule stuff done. I was going to do like the first Mondays of the month, but then that just didn't work out for January. And I still want to figure out when to do it for January. So whatever I end up doing for January is going to be all the way through the year like that. Yeah, they're trolling us. No, today was not the hearing. The hearing happened yesterday where they decided that they were going to do like a half-C type hearing. And then there was a document that popped up and it was like the media wanting in. And then they said that it got, I guess, submitted like too late. So they couldn't even consider it before the hearing actually happened is how I understood the document. I was going to do a video about it after I was done with what I'm doing today and post it tonight or first thing in the morning, just so that we kind of like had an idea about what was happening before everything started. Yeah, I was talking forever. I was like, oh crap, they can't hear me. But yeah, I don't know. I don't know what this is. I don't know either. I don't know what's happening. Hey Cricket. Yeah, we're gonna figure it out. Yeah, shite happens. Hello, hello. Yeah, we're gonna see if it closes at 4 o'clock, if something happens. Exactly. Right here. Never know. Better safe than sorry. For sure. Nothing as far as I know, nothing till tomorrow. So I'm really confused about why this is even happening. Our snow is still on the ground here. It snowed really, really cool, which we hadn't had snow in Texas in I don't even know how long, like literally forever. And it's actually still on the ground. My backyard, about half my backyard still has about like 3 inches of snow just kind of stuck there, but it hasn't rained or like done anything else. Yesterday was about what they were going to do. But see, I also remember that they said that they were going to have meetings right before hearings every single time anyway, I think, to determine whether Bryan was going to be able to wear his suits and stuff. I think that was something that they were going to end up having to do like every single time. So that might have also been what happened yesterday. And did you guys see the post I put in my community tab? I don't want to like deviate off the screen in case something happens because you honestly just do not know. But did y'all see where Steve Goncalves apparently told some news station that he had to pay like $5,000 to show up, and now he's upset that the families aren't even going to be able to like sit in to the hearing that's happening tomorrow? And I'm like, you didn't pay $5,000. Your people all over the GoFundMe's and stuff paid $5,000. And also, why the hell are you spending $5,000 to go to one day's court? Like, why in the hell is that costing 5 freaking bands? Like, I mean, that's $500. Why is it costing $5,000 to take you and a few people in your family for one day down there? You're not needing to spend the night. This is a 1-day thing, right? Or I guess there's a 2-day thing. But they're like, I just don't understand. How the hell $5,000? How do you need $5,000 to get there for right here? I don't understand. That's a lot of money. Like, I could travel a hell of a lot farther and do a lot more than what they are claiming to be doing with $5,000 for just like a day or two. That's insane to me. Like, that's some bougie ass spending. Yeah, how many for $5,000? But see, that's the thing. If they're going to fly and spend all that extra money because they're too bougie to drive, then that says a lot too. Because you could literally just drive and it make it like be a day trip. I mean, I don't really understand. Exactly. Like, what are they feeding themselves? See? Exactly. I just don't understand. Exactly. Exactly. And if they're just supposed to be there overnight, like say they drive in the morning, get there for the beginning of the hearing, spend the night one night, go to the next hearing, like if that would have been the schedule, and then they went home after that, like $5,000. Are you wild? I mean, apparently he's wild. Hey, sir, we don't know what's going to happen though, so you might have could have slept in. Hey, Summer Jade. Right? Like somebody commented like they traveled all over the entire country for 5,000, and I'm like, yeah, I don't understand. And then to sit there and say it the way that he apparently said it to them, I'm like, you should have said our supporters donated the money for us to get here, and now their money just got wasted. Because to me, that meant that you like put a down payment and stuff down for wherever you were going to be, or you prepaid the hotel or something like that, right? So $5,000. Boy is crazy. Boy is crazy. Absolutely insane. It is $5,000 for an overnight, basically, like a drive there overnight, go home situation. That's a lot of money. Lots of money. No, he asked for 75,000, but he spent apparently 5,000 on an overnight stay. That makes no sense. See, at 5.2. Okay, let me hold on. Let me go. Let me check. Let me check where I'm at. Hold on a second. Is there like, okay, this is going to go back now, and I'm going to refresh. Is there a third notification? No, it's still at 4. It might have been, ooh, Zelda. So my cat's in here. She's jumping all over the place. It might have been for your time zone, maybe. Welcome, Elser. Welcome back. Welcome back, Elser. But yeah, I don't know. I mean, you would think. And never mind the fact that literally like the entire county has offered them free room and board. Hey, you can come eat at my restaurant for free. I'll feed your entire family, stuff like that, on top of almost 80 grand. Like, it's just absolutely insane. And I am going to say on top of like 80, even though the GoFundMe is, I think, at 75, because they have Cash App and PayPal and a Venmo and like all these things that they're getting money from. So it's definitely more than what they're acting like. Bro, I don't even know if it's going to be a hearing. I don't know what's happening. But we got 13 minutes to figure it out. Yeah, she's a rescue kitty. We found her in the parking lot of a Dollar Tree, and she had been hit by a car. You could tell she'd been hit by a car. She had like a twisted up hip and a broken leg, and her tail was messed up. She had a big spot missing on the top of her head. She was malnourished. She was horrible, like horrible looking, poor baby. She had her bone sticking out, and she had a big, huge chunk of meat missing in the back of her other leg that wasn't broken. And so we got her, brought her home, fixed her up, and now she's a spoiled little brat. Quit it. And she really likes wires. So she's like constantly trying to get all of the wires, all the places. She was asleep, but then I started talking and now she woke up. So there's that. Oh, well, thank you, Wendy. Thank you, Wendy. I don't know if anything's going to happen here, but thank you. I just don't know what's going on. I don't know if this is a mistake and they're just checking the cameras for tomorrow or something, because they literally had a hearing yesterday. I don't know what this is. I have no clue what this is. See, parking lot cats are the best. Parking lot key cats are the best. She's about to fall back asleep in my hands. Oh, nope. You're not playing with my cords. Oh, I'm trying to get her to meow, but she doesn't really meow. Are you talking about the younger one? I don't watch any of that stuff. I mean, it kind of makes me nauseated half the time just to look at their Facebook page. I still find it hilarious that they blocked me at some point, and then they would have had to have gone into their block list to find my name in order to unblock me. I wish I knew what that was all about. Wild. Well, thank you. Oh, of course. Little baby kitty cat. It made me, I'm so glad, because like every single time we get like a bad storm or like this snow stuff, I'm like, I'm so glad that we found you and you weren't out in this stuff, because what would you have done? Crazy. Yeah. See, he's got like all this information out there about how he like self-identifies as somebody with so much money, and then he acts like this. It's just wild. I mean, honestly, we don't even know, SB. we're waiting to see what in the actual world is going to actually happen here, because we have no idea. This just like popped up out of nowhere, and I decided to just pop up out of nowhere too, just in case, so that we don't miss anything. And I haven't been live in like forever, bro. How long has it been since we had a court hearing? I haven't got to talk to you guys in real time in forever. That's going to change soon, because I actually miss like having conversations with y'all live like this. So yeah, we're going to try to figure it out. I don't know. We're going to figure it out. Let me refresh back and see if it's done anything different. I mean, there's 80 people waiting on the live one to see what's going to happen. Chat disabled. Well, they at least disabled the chat this time. Wasn't there a couple times with Latah County that they left the chat on? I was like, oh, they brave today. Oh yeah. It really, that's what made me like rethink how I felt about them. Because there was there's one video. I never take any of my old stuff down when it comes to this case, especially. There's a video still on my channel where I was like taking up for Steve, because there was like some FBI agent that came out and said a bunch of crazy stuff. And I was like, what is wrong with you? And there was like other people like being crazy too, just being so horrible to them, like right off the bat. And I already knew that like that's how this happens a lot, right? And this Sam stuff, like finding out about Sam and finding out the story behind Sam, I was done with Steve at that point. Like I just, once you show me who you are, it's really hard to unshow me who you are, and that goes for whoever is in my life. Like once your true colors are flying and shining, then I'm. I don't know, LR. We're trying to figure it out. This just popped up out of nowhere. See? 19 years, fat and sassy. I'm literally seeing the fat and sassy lady in my head. So I don't know what's going on. We're going to find out, hopefully. I guess I can show y'all this document, though, real quick. Let me see if I can pull it up. Yeah, right here. So this one is the one where they deny the petitioner's motion because it apparently, like they said, because of untimely filing, which is hilarious because timely filing limits is something I have to deal with constantly in my job. But like they apparently got it all down and this was filed too late, but it's definitely from all of the media people. See, it's American Broadcasting Companies, ABC News, Associated Press. It's yeah. And I think it's just like the same thing over and over again. And it's just them, they've done this before, this interested parties thing. I guess I just forgot. But Yoli, she's an attorney. I don't know if you guys, some of y'all should know who Yoli is because she's over on Andrew. Oh, I don't want to say his last name wrong. He's the lawyer. He's the one I talk about a lot because he's really like unbiased and tries to like look at both sides. And he has like little panels and stuff. And he also put Howard Bloom in his place quite a few times. So she's over there a lot, but she was telling me some information about it in my community tab. And I was like, could it be somebody like in Kohberger's family that maybe is like, bro, I want to know how all this stuff happened to my DNA, how you got my stuff. Yes. Andrew Myers. Oh, I missed a yellow thingy. Oh, thank you, Connie. That's very sweet. Thank you. Yeah. Andrew Myers. Yep. That's the one. But I asked, I was like, maybe it's one of his family members that's like, no, you're not going to shut this out. I want to know exactly what the hell happened. How'd you get my DNA? How'd this happen? You going to tell me right now? That's what I thought it might have been. But media, it makes sense. Yes, she does. She does have her own channel. She does. Actually, whenever this one's done and over with, depending on what happens, and holy crap-a-moly. What is happening? So what is going on? Like, this is actually going to happen? Is this really about to happen? Twizzle quit. Like, this is really about to happen. You know what? It could be the media meeting, but I don't know if they would need to do all that. I don't know. I'm so confuzzled. I don't know. Hey, Danny. I don't know what's happening. Yes, it does. It definitely says Kohberger. It does. I don't know what's going on, though. I mean, yeah, let me like refresh and make sure that it's on the right thing. Well. Bro, it probably could be. But then this, I don't know, what time is it? Oh, I guess this is like maybe an automatic screen for the 5-minute counter. Is this a test? Bro, maybe. I don't know, Valgal. We're all very confuzzled and trying to figure it out at the same time. They had people joking about that. I'm like, bro, can we just chill? I know, excited and confused because I don't know what's happening. It is probably a test, but it's a wild test. It's a wild test. I don't know what's happening. It would be wild if they actually dismissed it. If there was something that he saw and he's like, yeah, we can't do this. I don't know. Very confuzzled. It's 3 in Boise right now. Oh, that's true. Isn't Moscow and Boise on 2 different, or at least some split in Idaho is like a different time zone, right? Something like that. Yeah. I mean, that's what this one's supposed to be, but I don't know what this is for because nothing was supposed to happen today. Like, I can even go back to, like, this is the other document that came out about the hearings, and it doesn't say anything about the 22nd. It still says everything about the 23rd and 24th. So I don't know what's going on. I don't know what's happening, but we're going to figure it out together. I mean, this is wild. Like if you really think about it, like this is happening right after he looked up a bunch of the stuff about the IgG. So who really knows? I don't have any clue. So y'all are just getting like notifications from the 4th District Court? Because my notifications never come through. But I get that from y'all too, that a lot of times y'all don't even get my notifications. I'm just like, what's about to happen? 3 yesterday? Jeez. See, and I have like my creator studio and my YouTube app on my phone, and I never got a notification. But then again, I don't even have it all the way on, do I? Look at that. Oh, no, I do. What? Law and Crime is saying that it's an actual hearing? Or are they just seeing that it says State versus Kohberger and are just assuming like we all are because we really don't know? I'm so confuzzled. I don't know, Mr. Centennial. Your guess is as good as mine. See, but I don't know if they would do it like this because of safety reasons. I feel like they would have let him go and then announced it, honestly, because, I mean, that's how my shit went whenever my ex got out and my life was in danger for a whole, like, 36 hours before I was notified. So, who knows? I can't drop, oh, can I drop a link? Yeah, if you want to watch if you want to watch it without all of this chat stuff, feel free. That doesn't bother me. I know sometimes whenever I'm watching stuff, I got to be somewhere where there's no chat option so that I don't get distracted. But I just dropped the link to the actual stream on the State versus Kohberger, Idaho 4th District Court link right there. If you should be able to see it. I don't think so. Jeffrey Toobin? You did? I'm so like, what is happening? Let me check is there another document or anything? Yeah, look, there's not another document about anything for today. Like, this is the old one. This is the old one about what was happening yesterday. And we went through the other ones. So, I don't know. This is so wild. Toobin versus Samuel Hyde. I'm going to have to look that up. Yeah, 2 minutes to go, and let's see what's actually happening. Ooh, do they have a summary already, even though there's nothing there? Where do you see that? Where do you see that at? Oh, look, even Dinky's like, what's happening? I don't know. I don't see a summary because the chat isn't the summary normally in the chat. See, I don't know. I don't like AI. I don't really pay attention. East Idaho News. Is it their Facebook page? Not Facebook. Why am I freaking thinking Facebook? Is it their YouTube page going live to try to cover whatever the heck is actually happening here? It was Marley. We don't have any clue. We're all confuzzled at the exact same time, and we're all gonna have answers at the same time. I don't have any idea. Oh, good point. Case summary. Let's look at that. Let me pop this open before I show you guys. Oh wait, it's 4:00. I'm listening to see if something pops up. If we went through all of this and it was for nothing, I mean, I'm glad I got to see you guys, but this is crazy. It's on Vine. I don't get I get emails for that, and I have nope. The case summary has not been updated since yesterday, and there is nothing on it whatsoever. See, we have the reply, this part, and whatever happened yesterday, and then the one that's supposed to happen tomorrow. There is nothing. Oh, good. You have food to binge watch this with. Yeah, I'm gonna have to check my emails for any Vine notifications. Let me do that real quick. I don't have any clue what is happening. And I'm not seeing anything like on Twitter when it comes to like Brian Inton or anybody knowing some information, because you know Inton usually got some info. But I don't see nothing like that either. Let me check my emails. My phone is so slow. The judge did deny the media's motion because it was turned in late, I think. Like it wasn't turned in timely. So they didn't have like time to review it. I don't have any notifications from Vine. I mean, YouTube hates their creators. That's the only thing I could think of, because they don't help us try to do anything here. So I don't know, but I guess we're gonna find out if something happens here. I mean, crazy. I don't know what in the world's gonna happen. We're gonna find out though. I think like everybody is just assuming that's what it is. I think everyone is just assuming at this point that it's a motion hearing. Because I don't have any idea. Let me see if I can see anything different on Twitter. No, just a bunch of people saying this might be a mistake, but it says it's going to be live, and it says it's going live. It's just people asking about like why this is happening. Yeah, Honeybee said, what's going on? Yeah, it doesn't really seem like anybody really knows. We're all just trying to figure out. Spokane News did? Even Court TV is streaming it. I know. I think that like people are just like really confused. You did? Okay, let me go look. I don't have a tag. I don't have a tag on Twitter. Unless it just hasn't like done its thing yet. Oh, thank you, Liza. Oh, you know what? Girl, check this Facebook group. Let's see. Headed to Boise. Please say some prayers. As of 6 minutes ago. As of 6 minutes ago, they posted that they were headed to Boise. Holy guacamole. So something could really be happening here. Something could actually be going on. Like, why would they just post that 6 minutes ago whenever this just popped up on here? I don't know. Like, at this point, I'm dropping everything that I already had planned for everything until we figure out what is happening. The Goncalveses said that as of 6 minutes ago, they were on their way to Boise. Look, I'm telling y'all, I have always kept a little bit in my brain that there could have been some sort of magic ninja possibility, okay? And if they were able to... Oh, whoa, whoa. Look at it now. Yeah, like my heart's actually like racing a little bit. Like, what's about to happen? Somebody's breathing heavy. I can hear it. Thank you.
All right, we are on the record in State versus Bryan Kohberger, CR 0124-31665. The state is represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. The defense is represented by Ms. Taylor and Ms. Massoth. The defendant has been excused from appearing. The defendant himself has been excused from appearing today. With us also are petitioners, counsel representing petitioners, Ms. Olson and Mr. Pedersen. Today's hearing was set to address the interested parties' petition to be heard as interested parties related to the court's closure of a portion of the hearing set for Thursday and Friday. So with that, I will let, whether it's, I'm not sure if Ms. Olson or Mr. Peterson is addressing the court today, but whomever is may address the court.
Thank you, Your Honor. It will be Ms. Olson on behalf of the interested parties who are various media organizations and professional journalist organizations with a history of covering the proceedings in this case. And the interested parties thank the court for this opportunity to address this issue regarding press and public access to the hearings that are scheduled to start tomorrow at 9 a.m. Your Honor, as the court knows, the United States Supreme Court has long acknowledged that the First Amendment protects the rights of the public and the press to attend criminal proceedings. And while few cases in Idaho have dealt directly with public access to pretrial proceedings, and in particular suppression hearings, at the federal level, both the United States Supreme Court in Waller versus Georgia and the Ninth Circuit in Associated Press versus U.S. District Court for the Central District of California and in United States versus Brooklier have addressed the issue. Waller did so in the Sixth Amendment context. Brooklier found that the First Amendment right of access extends to suppression hearings, and in Associated Press, the Ninth Circuit extended the logic in Brooklier to pretrial filings, writing in the very first part of its opinion, there is no reason to distinguish between pretrial proceedings and the documents filed in regard to them. Notably, both Associated Press and Brooklier involved high publicity, highly public defendants and charges. Associated Press involved federal narcotics charges against, among others, John DeLorean, and the Brooklier case involved a RICO prosecution against members of the criminal enterprise La Cosa Nostra. Waller, in particular, in its decision, sets out the benefits that the U.S. Supreme Court has seen in its various decisions that arise from public proceedings in criminal cases. It notes that in Gannett, a case in which the United States Supreme Court looked at but did not decide the issue of press access to suppression hearings, that the requirement of a public trial is for the benefit of the accused, that the public may see he is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and the importance of their functions. And in turn quoted other cases. In addition to ensuring that the judge and the prosecutor carry out their duties responsibly, a public trial and public proceedings encourage witnesses to come forward and discourages perjury. Your Honor, prior to closing a criminal proceeding, a court must afford those excluded from the proceeding a reasonable opportunity to state their objections. We appreciate the court providing us that opportunity here. And the court must also comply with the requirements set out in Press Enterprise 2 before it can close those proceedings. A criminal proceeding can only be closed if the court makes specific findings on the record as required by that case. And those specific findings need to be sufficient in writings, insufficient so that a party excluded can challenge them. The Ninth Circuit has explained that a court cannot be closed in criminal proceedings unless such closure serves a public interest. There's a substantial probability that in the absence of closure, this compelling interest would be harmed, and that there are no alternatives to closure that would adequately protect the compelling interest. And that's in Oregonian at 920 F. 2nd at 1466, quoting from the Press Enterprise 2 test. Here, Your Honor, the interest parties are not arguing for a blanket order opening the court. We are arguing for the court to adhere to this long-established process of determining how and under what circumstances a court could be closed for a hearing. For many of the media outlets we represent, even in national security, child sex assault, and organized crime cases that they cover, the process that we are seeking has been carefully followed. The public and the media have a right to appeal unwarranted closures of a courtroom, but they're unable to determine whether the court is being closed appropriately because the court so far has not made public the most basic information regarding the reasons for its closure. The defendant in this case, in both its January 13th and January 21st filings, seeks an open hearing and asserts that an open hearing is of utmost importance to him. Therefore, any concerns about the closure being required to ensure the defendant's right to a fair trial are moot. And as Mr. Kohberger pointed out in his motion to hold an open hearing, the Supreme Court in Waller held that when the defendant objects to the closure of a suppression hearing, the hearing must be open unless the party seeking to close the hearing advances an overriding interest that is likely to be prejudiced. The burden is on the party seeking closure. That's from Oregonian 920 F. 2nd at 1467 and Brooklear 685 F. 2nd at 1167. As we understand it, Your Honor, the interest being advanced by the state is concern for information being provided to the potential jury pool and possible inadmissible evidence being discussed in open court. But that is inherent, Your Honor, in any motion to suppress hearing. The whole basis of the hearing is to see whether the evidence should be excluded or admitted at trial. Concern about the public maybe learning about this evidence, and even if it ends up being inadmissible, is therefore not an overriding interest. And absent that some evidence that this discussion that would occur in the hearing would prejudice, would taint a jury pool or provide information that would be difficult to seat a jury, I think that is also not sufficient evidence for this court to find that it's a compelling interest and warrant closure of the hearing over both Mr. Kohberger's objection and then the right of public access. It also appears from Mr. Kohberger's filing yesterday that the state asserted that Mr. Kohberger's acquiescence to the non-dissemination order is somehow a basis for them to argue that Mr. Kohberger cannot now object to this closure. Not certain if that was the argument the defense, that the state advanced, because we haven't seen their pleading. It's not on the cases of interest website. But as I understand the non-dissemination order, Your Honor, and its purpose, it's directed at comments or statements that are made outside of court proceedings and pleadings, and not at what can be said by the parties or their counsel in the courtroom. And the very purpose of the non-dissemination order, as I understand it, Your Honor, was to prohibit those sorts of extrajudicial comments by people who would be in the know, but that in-court proceedings are precisely the kind of information that should be available to the public as this case moves forward. Your Honor, I would submit also that there is tremendous public interest, and it serves a tremendous public good for the public to know at the time that it's being considered the evidence, whether the evidence that the state seeks to introduce at trial was gathered in a method that is constitutional or meets evidentiary thresholds for admission. A motion to suppress may be the critical stage of a criminal case. If essential evidence is suppressed, then the government will not be able to meet its burden of proof at trial. Indeed, Mr. Kohberger made that exact argument in his filing yesterday. The purpose of the IGG was to investigate a criminal case. What is more, without IGG, this case would never have been brought against Mr. Kohberger. The public should know precisely what law enforcement and prosecutors did in gathering such evidence and why and how the defendant thinks that was illegal. The court in Waller, when it was talking about the aims and interests of a public trial, noted that those aims and interests are no less pressing in a hearing to suppress evidence. And then they pointed again to several of the individual opinions in Gannett, the case where many Supreme Court justices opined that if they were addressing the question, they would say there's a First Amendment right of access to suppression hearings, but they didn't reach that question. In Gannett, the comments that many of those justices made was that in many cases, the suppression hearing was the only trial because the defendants thereafter pleaded guilty or the evidence was suppressed and no case went forward. And similar reasoning supported press access to preliminary hearings in one of the few Idaho cases to address access to pretrial hearings, and that was the Cowles case. In Cowles, the Idaho Supreme Court noted that the process in conducting preliminary hearings in Idaho is likewise sufficiently like a trial to generally justify public access. And they pointed to the Supreme Court opinion in Press Enterprise 2, where they state that because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. The preliminary hearing in many cases provides the sole occasion for the public observation of the criminal justice system. And that may be the case in a motion to suppress hearing, particularly if either that motion is granted and not sufficient evidence exists to go forward, or even it is denied and a plea deal follows the resolution of the motion to suppress. In a Franks hearing, Your Honor, the court is addressing the very critical issue of whether a law enforcement officer made deliberate or reckless false statements in an affidavit submitted to the court. And prior to holding such a hearing, a court is to determine that whether the defendant has made a sufficient threshold showing that an actual hearing is necessary. An actual Franks hearing, in my experience, Your Honor, is unusual. On issues as critical as these, whether evidence was gathered properly and whether law enforcement made deliberate or reckless false statements to a court in gathering evidence, there is significant public interest, and public access plays a significant positive role in the functioning of the particular process as the court outlined in the earlier cases I've identified. It's particularly true here, I think, Your Honor, with the Franks hearing, where there is that question regarding the truthfulness of the officer involved. In any criminal case, I would submit that it's of extreme public interest to know whether a law enforcement officer swearing that they have told the truth in a filing with a judge that will be used to gather evidence that can significantly impact the life and liberty of an accused, whether that law enforcement officer did in fact tell the truth or whether the officer made deliberate or reckless false statements. I think it would be different, Your Honor, if it were a private citizen who made a misstatement of facts and there was a hearing about perhaps that person. The calculus might be a little bit different, but this is a person, a law enforcement officer who is cloaked with authority and has the ability to seek process, to get evidence, and ultimately lead to charges against an individual. Your Honor, the last thing that the court has to look at with respect to whether or not to close a hearing is whether there are alternatives to closure. And Your Honor, it is a little difficult in this situation for the interested parties to specify what that alternative to closure might be. But sort of looking at the documents that have been filed in this case and understanding that one of the initial concerns with the IGG evidence is the identity of perhaps family members of Mr. Kohberger, I would submit that there are two alternatives at least that might address that. One is that it's possible, of course, to show exhibits on a monitor in a hearing in court in a way that they're not displayed to people who might be watching online or in the courtroom, similar to what is done when there is a piece of evidence or an exhibit that is offered, but it's not yet admitted. Would also submit, Your Honor, that perhaps redactions or some sort of general identifier, person one or person two, in the place of a particular name would be sufficient if indeed the concern is revealing the names of relatives of Mr. Kohberger. That's very similar to a process that is done in healthcare fraud cases when we're dealing with individual patients whose records may be at issue in a case, and not a medical malpractice case, but a healthcare fraud case where we're looking at the billings, and those individuals are often identified, for example, by a random number or by a Medicaid identifier number, and not by their name. So their names are never revealed in the course of the proceedings. And so, Your Honor, we would submit that alternatives to closure such as that would be available to the court if the concern is identifying those particular names of people who are extended relatives of Mr. Kohberger. Finally, Your Honor, openness and transparency are more important than ever in maintaining and restoring public confidence in our government institutions, in our courts, in law enforcement, in prosecutors' offices, and in institutions of the media. Open hearings, like an open suppression hearing, are necessary to let the public see how this critical part of our criminal justice process works. Thank you, Your Honor.
Thank you. Does either the state or the defense wish to add anything based on Ms. Olson's argument that was not previously presented?
I would like to make a record on behalf of the defense.
Beyond what you did yesterday?
It would be consistent with what I did yesterday.
Okay, but I heard what you did yesterday. So do you have anything new to add?
I don't have new information to add, Judge, other than having the ability to talk with the team about what your suggestion was and our concerns about arguing in open court. Would you like me to just address that?
I'm not sure what you're referring to, so I apologize.
So we had discussed that the evidentiary hearing portion of it for the IGG would be closed.
Correct.
But that we would argue the legal arguments in open court if we did not talk about the evidence that was brought out in the closed hearing. And after thinking about it overnight and talking about it today, we do not think that we can parse the argument that way. So it's still our position that all of this should be held publicly, openly in court. And that's our same position with the Franks. The Franks proffer, with the exception that there will be, in the proffer, there will be a need to talk about specific names and in particular names of some lay witnesses in directing the court to the 1,000 pages that were submitted under seal in relation to the proffer.
All right. Well, with
So
respect to
that's the
the names,
that I have.
I'm sorry. With respect to the concern with respect to using names, submit a list of names with initials tomorrow, and you can use the initials.
Okay, we can do that.
Anything from the state, Mr. Thompson?
Not for me, Your Honor. Mr. Nye was actually speaking on behalf of the state yesterday. I'll defer to him.
Mr. Nye?
No, Your Honor, nothing beyond what was said yesterday. Thank you.
Well, I appreciate the presentation today. I will note this case is a little bit of an unusual posture in that there was previously a non-dissemination order issued in this case in which it was clear the tract of the court and at the time the parties was to avoid given the media scrutiny, the potential for impacting the jury pool that exists here with evidence that may ultimately not exist and evidence that may not ultimately be admissible. That order was challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that. The closure of the proceedings thus far have been consistent with that prior ruling by the court for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given the intense media scrutiny that has and continues to follow with this case. Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. It's exactly why it's not open. We will be challenged under the best of circumstances of obtaining a jury that is not been overly exposed to this, and in particular exposed to evidence that ultimately may not come into this trial. I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to. And I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal. That said, with respect to in particular, the IGG issues, particularly where I don't exactly know what the evidence will be forthcoming, I am concerned about the potential impact on a jury pool. In this case was moved to this court because of the defense's assertion that they could not get a jury pool in northern Idaho that would be unaffected by the case, even with the non-dissemination order in place. The media here in Ada County is as, if not more, intense. And so I think there is need to be careful when we are addressing evidence that potentially is not going to be evidence in the case because of suppression motions in limine and the like, which is the concern that I have in particular with the Frank's hearing, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date. As I talked with the party, there are other issues that I've asked the parties not to address specifically as it relates to some of the motions to suppress that doesn't need to be discussed specifically. For example, the evidence produced by the warrants they seek to strike. And is for that reason, my intent has been and continues to be that we will have as much of this hearing open by way of streaming possible. I have not and will not open the courtroom itself to parties in the courtroom because of the need to close it if I find or the parties suggest to me, and I agree there's a need to discuss something at that moment outside the public's reach. which is easy to do by simply going offline for a minute. And that's what I intend to do tomorrow. In particular, the evidence with respect to the IgG, I think at this point it's appropriate to, and I will issue an order shortly to keep that out of the public domain for the time being. Now, that may change down the line. My order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the factual details, until I know what those are, and I've seen that, I can't make that determination better. And so I think that this is the best way to proceed because I can't unring a bell once it is rung with respect to potential evidence that in particular may not be evidence in this case. And so my intent would be to proceed with the evidence portion of the Franks hearing as it relates to IgG in a closed environment. I think we can decide at that time before we go online whether we can have the IgG portion of the Franks proffer publicly. The intent is, I think we understood from discussion yesterday that the rest of the evidence and the arguments, both on Franks and suppression as it relates to everything else, we should be able to do public. If there's an issue that is specific, like Ms. Massoth brought up about the need to mention a name that we need to protect from unwarranted harassment, which has been a concern in this case, we can certainly refer to them by initial, particularly if you give me a roster with initials or other identifiers you'll be using, then I can follow along. And I think that's the better way to proceed so that we can do as much of this in open light as possible. So I appreciate the petition. I don't think it has changed. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly as was offered to me. That doesn't give me comfort, to be frank. But for the meantime, until we can, I can get a handle on the exact evidence that does in fact come in, given that it is potentially evidence that will not be admissible, and anyone who hears about it may therefore be removed from the jury panel. I think it's better that we proceed in this fashion for now.
May I raise one other issue, Your Honor?
Briefly.
Thank you, Your Honor. So first, Your Honor, with respect to the non-dissemination order, respectfully, we represented the interested parties at that time as well. In our understanding of those proceedings, it was amended a couple of times. The second time after we moved to intervene and challenge the dissemination order then in place. And as I understood Judge's, the proceedings in front of him and the non-dissemination order, the purpose of that was to preclude extrajudicial statements and was not to preclude the attorneys from saying things in court that would be made public. The goal was to make sure that there was accurate information from people knowledgeable about the proceedings, and that was the forum in which they could do it. And I would also note that Rule 3.6 does have sort of this rebuttal portion to it that allows if the defense, if there is a statement that is made, under Rule 3.6, the defense is permitted to make public statements to sort of counter that. And I think that's probably what the defense was getting at in its submission to the court. And then finally, Your Honor, are the court's statements in court today intended to be its specific findings regarding the manner in which the court is to implement the Press Enterprise 2 test, or will there be a written order so that my clients can be adequately prepared to decide what next steps to take?
Yeah, as I indicated, I intend to issue a written order following today's hearing. I don't think that what you said accurately reflects my understanding of the defense's position yesterday, but I appreciate that. I do understand judge's prior order to be dealing with extrajudicial statements because that's who he could control at the time, were witnesses and parties. But I also understand from a review of the record, there has been a concern throughout this case of exposure to evidence that may ultimately be inadmissible, and that prior proceedings were closed for that purpose, consistent with judge's ruling at that time. I agree it would be an extension of that, but in general, I think that's where they've been throughout this case. So, at the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial. So it's a bit of a narrow path for the court to have to tread, and I appreciate that, and I appreciate that that calculus isn't always in the direction that one would hope, but I am doing my best to make that calculus in a way to ensure the rights of the parties and to ensure a fair trial, and that we can do that as quickly as possible. All right, so I will issue an order forthwith, and tomorrow we will come forward with public hearings just as soon as we can. Further, if after hearing that evidence, I determine it doesn't need to be protected, I will order a transcript be prepared, and I will order that be produced. But in the meantime, I think I need to take this course, so I appreciate that. Thank you.
Thank you, Your Honor.
Did they really just say all rise and he was the only one in the courtroom?
No one seems to.
Oh boy. Okay. Well, it sounds okay. I only have a few minutes before I gotta go run and do things. This is how it sounds like to me. It sounds like he's saying that eventually everything is going to be unsealed, which is wild. Could you imagine? It's going to be so many videos just to be able to go over the information that they're going to unseal, because just what they're talking about here, they got turned in for these motions. I mean, I think what was it? The Franks? It's like over 1,000 pages. 1,000 pages. That's so much information. I don't even know how to properly think about how much information 1,000 pages is. That's absolutely wild. But it sounds like he's saying, and honestly, it makes sense. This has been my argument this entire time. We have spent the majority of the last 2.5 years or so now, 2 years or so, fighting about the freaking IGG, like literally. And the state has told us from the very beginning that they were going to file a motion of limine and not even present it. And that's why it made me like pretty much feel like I was insane, because so many people were basically being mad with the defense, because now the defense was wanting to get rid of the IGG stuff. And I'm like, okay, but the state's been saying the same thing. And then we go back further, you go back to Don Daniels, and Don Daniels was asking the magistrate court to ignore the fact that she even knew anything about the IGG before they went and did the search warrant at his apartment. So this investigation has been literally asking for the IGG to be not considered in anything since the very beginning, and before Bryan even got back to Idaho. That's why I'm like, no, y'all got to show us this, because there's a reason why y'all been acting so freaking shady about it since before he even got back to Idaho. And it makes me feel like they were being shady about it since before he was even actually arrested in Pennsylvania. I just don't understand why they can't just go public with all this stuff from the beginning if they're just going to use initials anyway, or they could create identifiers, or why the hell are they just getting a list together now? Like, you heard him, he just said, get a list together with initials and give it to me for tomorrow morning. Why haven't y'all done that already? Like, this has been an argument since the very beginning. So I don't understand. I mean, we don't know the initials of all the family members because we don't know how many people are actually involved in the family tree that they actually pulled. Now, like I mentioned before, and I think I mentioned it in chat here, there are a few channels that did go in and get a bunch of that stuff from his apparent IGG or whatever family tree stuff off a couple of very public websites. And, you know, it's there. A channel that should not be named. Those of you might, you know, that have been here for a long time know who that is. That channel has that stuff about his family tree stuff that she found on the interwebs. I see this question a lot, and I don't honestly know anymore because I feel like we have now gotten a completely 180 story to what we were originally told. Because in some of the paperwork that we got about a month or so ago, I guess, in all this motion to suppress stuff, the defense themselves are saying that the state is the one who got the IGG information, but that's not how we were told. We were told that it got sent to Othram, which would have been a state contract. But then Othram was told to stop what the hell they were doing, and the feds came and took over the IGG, and the IGG got sent to MPD by the feds, who were actively investigating the case, which is why this whole tip thing to me, I don't give a damn. To me, it's not a tip. You were actively investigating this whole entire situation. This was not a tip. You were part of the investigation. So I don't know. They can't say it was the state in the defense paperwork and not make, you know, not think we're going to ask questions, because once you take it away from Othram, that's no longer a state entity. You've given it now to the federal government. It's not the state. It's the country. I don't think she said new evidence since yesterday's hearing. I think that they just like regrouped after yesterday's hearing and she wanted to say something else. I just want to appreciate how much of a smartass he just was, because I don't give a damn that she said it yesterday, bro. Now we're on camera. Let her repeat it. Shut up. Let her talk. There's channels. I mean, I don't know if those people have taken the videos down, but there are channels that have gone in and seen from official, it was like actually official ancestry websites. They put in his information after they were logged in and it popped up. No, I don't mean her. I don't mean her. The idiot that I did the conversation with Kara on has that stuff. That's why I don't like talking about her, because she's a freaking menace. So that one, she's got a video up from a long, long time ago where she put that information out there. But I don't know if she's the only one, and I doubt she's the only one. But I just don't understand. I mean, I get the point. I get his point, but I don't get his point at the same time. Because if your whole intention is to not, if the whole intention is for most of this stuff to be like suppressed, taken away, motion of limine, taken off, all the stuff. I mean, I just don't get it. I know I say crazy stuff, bro, when I'm aggravated. My mouth just goes wild. That's why I can't be a lawyer, because I'd have been held in contempt more times than everybody combined. There's just no way. So I don't know. I don't know. This is annoying me. It just really is annoying me, because at this point, like, just show us what y'all have. And if you really don't have what you're telling us that y'all have, then freaking be honest and let's get to the proof and the facts and let's get somewhere. Like, this is dumb. Love you too. But this is stupid. I don't understand it. I just don't get it whatsoever. I mean, I'm glad that he did say, yes, very. I'm glad that he did say eventually everything is going to be unsealed, because holy crap, that's going to be so much information. That's going to be so much information. I just wish that they would be more organized, I guess. Because like I said, like, why are you asking for initials now, bro? We're like 12 hours away from the hearing. What are you talking about? Like, why wasn't this something that was already done? And considering the fact that, you're welcome, considering the fact that the states had all of this stuff, then I don't understand why it wasn't already prioritized that way. They had no problem going in and putting BF and DM for Dylan and Bethany right off the bat. So why didn't they do that the second they got this family information? Why didn't they fix it? Yeah, she's a clown, bro. Don't go over there. I mean, go over there for the IGG video if you're trying to find that one, but just don't poison your brain with literally anything else, because so much of it is crap. Just wild. Oh, well, thank y'all for being here last minute, because I sure didn't know what was going on. I had no idea. And I even went back into the paperwork. I didn't see anything about them. Hey, Enid, I didn't see anything at all about them even wanting to get on here today. I'm glad they did, because I did show you guys the document. I was going to end up doing a video later on this evening with those 2 documents about what's supposed to be happening tomorrow and the 24th, and about how the interested parties turn their stuff in too late. I didn't think they were going to be heard at all, especially since we heard what Steve said to the news place about how, oh, we spent $5,000. You mean your people spent $5,000? You didn't spend nothing. But then I don't know what's going on either. Why are they on their way down there? Why 6 minutes before this started did the Goncalves' Facebook page say they were headed down there, up there, whichever way it is? I just don't know. But I'm going to go so I can get some stuff done. And I guess we're just going to find out what happens tomorrow. All of you guys that were here saw the information from the 2 documents. And I guess if the court order that he's talking about drops tonight, like if he actually gets it done to where his people go in and actually file it, because that courtroom are so slow getting stuff put on the portal. It is so bad. Like it'll go a whole week and we won't even have an update to the case summary, or else it'll update, because it almost updates the date every day, but there won't be any new information on it. And then all of a sudden, all kinds of info, but we have to wait like another 4 days for the documents, and it gets on my nerves. Yes, I'm going to have it on tomorrow. I will have it on and live tomorrow, and I'll be off the screen like I normally do. And then I'll probably go live tomorrow night so that we can talk about whatever happened. Oh, I don't. And that's why I record them. That's why I do it like this, because we realized from the very beginning that as soon as they're done, they get rid of them. And I'm like, no, we're keeping record. We're keeping record. Even though it's something like this that didn't have anything to really do with the case, we got to keep record. Really have got to keep record. Wild. You know what? Let me look real quick. I think it said 10 a.m. my time. Like it would be 10 a.m. my time. Let me look. Just to be sure, and then I'll get off of here once I get all of y'all the right date. Idaho 4th District Court. Let's see. See, look, for those of you who don't know how they do this, like this is the reason why. See how it's already gone? Like we literally just closed it off a few minutes ago and it's already gone. This is why I do this. Okay, I'm glad you mentioned something like that. He did say that he felt like they were being overcautious. Okay, 9 a.m. Idaho time, 10 a.m. my time, and I will be live 5 minutes prior to going live tomorrow. I'll get the link and everything set up today. But he did say that he had apparently already told them, and I guess this was mentioned yesterday, where we didn't get to see anything, that they're being overly cautious about stuff. And I'm like, okay, well then why aren't you just letting this like be open then? Like if you're already telling them, hey, y'all are doing this a little bit too much, then what are we doing? What are we doing? Insane. So I'm going to watch for that document that he talked about that he was going to put in right now. And if it drops tonight, then I'll do a little quick video and put it up there. Other than that, I will see you guys tomorrow. Hey, you. So y'all have a great, what is today? What is today? Wednesday? I don't even know what today is. What is today? Yep, Wednesday. Y'all have a great Wednesday. I'm going to go do some stuff. You might see me tonight, but you'll definitely see me tomorrow. Y'all have a super great night. And thank you, Enid, for joining. I forgot to show that. Let me pop it on the screen real quick if it'll let me. Thank you for joining. Thank you guys for being here. Thank you for those super stickers, those super chat things. Al Zelda, that is my leg. Your nails are sharp. Okay. Y'all have a great night. See y'all.